Good morning, Your Honors. May it please the Court. I'm Thomas Burns, and I represent Mr. Valesano. I'd like to reserve 5 minutes, please.
All right, you got it.
Some things simply cannot be unsaid. I think the parties have framed the issue very nicely in this appeal. The issue is, did Judge Tharp heed Barnhill and Goldstein and correct the way he imposed sentences, or did he instead hide his general policy of denying probation to all child pornography defendants? Now, in Barnhill and Goldstein, in the trial court, Judge Tharp gave very emotional speeches, essentially saying, hey, child pornography defendants, I'm going to impose very draconian sentences, and I'm not going to feel bad about it. And this court, in Barnhill and in Goldstein, said, Judge Tharp, you can't do that. You have to consider the individual circumstances of each defendant, and you can't impose a general policy of not allowing...
How do you know that he followed the policy here? I mean, can we assume that? You're asking us to make an assumption based upon a previous statement in a different case, correct?
Yes, but there's two parts to that. One is that he was actually biased. He didn't say this, and he was actually biased because he had previously said this before. And like I said at the opening of the argument, there are some things you simply cannot unsay, and that's just the way you feel about it, and nothing's going to change that. So that's one argument. The second argument is that it has to do with the appearance of justice. And here you have a judge who has said something. Not only did he say this in shorthand, but he gave very long speeches about how he felt about this. Now, in Barnhill and Goldstein, this court quoted what Judge Tharp said at length.
Let me ask this question. There is, I don't think, any dispute between the parties that the reasons Judge Tharp gave for imposing the sentence he did, taken at face value, were permissible comments, right? In other words, but for Barnhill and Goldstein, we wouldn't be having this conversation.
I think that could be right, and I think it has to do with, it's not just but for those two cases, but it's but for who the judge was. Here, the judge said, I'm imposing this sentence because of these circumstances, and I guess I would take issue with how some of the circumstances would aggravate the sentence, such as categorization and to some extent the nature of the photographs that were there. But a significant reason that we're here, obviously, is because of both Barnhill and Goldstein and because of the judge.
I guess what I'm getting at is, I think what you're asking us to do, right, is to say that the reasons that the trial judge gave for imposing the sentence he did weren't, in fact, the real reasons, and that the real reasons were something else.
Correct.
And is there any case that you can point us to where an appellate court in Florida has reviewed a sentence for undisclosed subjective impressions or opinions of a trial judge?
I haven't found that, but I think this is a unique circumstance. And part of the reason it's a unique circumstance is because we had a specific division in the Hillsborough County Court that was in charge of sex crimes, and that division had one judge, Judge Tharp. And so we had many years in which Judge Tharp was handling exclusively sex crimes cases. And I think that affected his imposition of sentences here.
Well, let me ask you this, because as you know, I authored one of those cases, the Goldstein case. And in the Goldstein's case, it was particularly disturbing, some of the comments that he has made. Had it ever occurred to you that he learned from these cases, he knew what would be appropriate consideration for sentencing, what things that are not appropriate, and in this time around, he recognized the fact that I cannot consider those improper factors, and instead, I'm going to consider things that are based on this record.
Of course, I did consider that, and in fact, that's an argument that the state makes in their answer brief. Again, I would say that there's the two parts to the argument. The one is that he was actually biased, and then the other is that you have this appearance of bias just because of what he said before. And I think either of those circumstances require you to reverse the sentence or vacate the sentence, I think would actually be the remedy, and then reassign on remand to another judge.
And I appreciate that, but also one of the factors that he could have, if he really was biased, he could have really sentenced your client to a great deal more time. I mean, the sentence that he received was actually a lower sentence than some of the things in Goldstein and in Barnhill. Can that be also another consideration in terms of appropriately determining the correct factors in this case?
Let me clarify your question. The sentence was actually higher than in Goldstein and in Barnhill, but are you talking about the guidelines?
The guidelines
Okay.
versus the sentence, because he could have received an additional 300 years if he really wanted to hammer your client, and he did not. He only gave him like a 30-year sentence.
He did, but that raises a separate issue, which is the way the guidelines work. The guidelines here calculated a range from 336 to 4,500 years. I think, for example, a 4,500-year sentence for having pictures on your computer for 3 months would violate the Eighth Amendment. The 336-year sentence also, I think, would present a close question on whether that violates the Eighth Amendment. So I don't know that the fact that the guidelines indicated something is really helpful to the court. I don't think trial courts ever rely on the guidelines. They do rely on the guidelines, but not in this kind of case, not in child pornography cases. They say, okay, well, this is what the guidelines calculate, and then here's what I think is an appropriate sentence. And in my experience, I don't really see, I in fact have never seen a sentence where they went by the guidelines. Instead, it was some departure downward, largely because there are bases for departing downward within the statute, like he needs medical help and so forth. And so it's really a judge-made practice. So I don't know that fact that you pointed to with the guidelines indicates something. I think the guidelines are actually broken in this kind of case.
Don't Barnhill and Goldstein at least implicitly acknowledge that the trial judge here is not dispositionally unable to fairly impose sentence in a child pornography case? In other words, yeah, at least one and perhaps both of those cases acknowledge, I think, that the sentence imposed might ultimately be a proper sentence, but in this particular case, they were just explicitly based on constitutionally impermissible factors. If we felt the way, if we felt the law was what your client now says it is, which is that Judge Tharp is just unable to impose a sentence in these kinds of cases, why wouldn't we have said it then?
You could have said it then. But the way courts usually work is you say as little as possible to resolve the case. That's when courts are on their most firm footing. And in that case, all you needed to say is what you did say. You said, he has relied on an impermissible factor, and therefore we need to vacate and remand, vacate and reassign on remand to another judge, so those impermissible factors aren't considered. But you just didn't address it. I mean, you could have dropped a footnote in that case that said, we're not addressing this issue. But, the way that case was briefed, none of these issues were raised in the first place. In Barnhill, the lawyer briefed the case based on not consideration of impermissible factors, but refusal to accept facts that were undisputed. And then this court reached that additional issue. Then in Barnhill, they did address that, it's hard to keep the names straight. In Goldstein, they did address that because Barnhill came out while the appeal was pending, and then it was rebriefed. But there was you don't have to hit the home run when you're deciding a case. You hit singles. That's the way courts work. So I don't think it is implicit, to answer your question, I don't think it's implicit in either of those cases that you did decide the question. In fact, I think what those cases indicate is that you left the question open for this case to decide that issue. So I think, like I've said, there's two different bases for ruling actual bias and the sort of implicit bias, or not implicit bias, but appearance of impropriety. And I think here the proof is really in the pudding. In Barnhill, Judge Tharp sentenced the defendant to 22 years, but on remand he was sentenced only to 10 years. And in Goldstein, he sentenced the defendant to 20 years, and on remand, the trial judge actually sentenced the defendant to 0 years. So I think the fact the fact that he did sentence those defendants so highly, the fact that he said such emotional things in such long speeches, and the fact that other trial judges have sentenced those same defendants to far lesser sentences is indicative that this judge is not seeing these cases for what they are. He's sentencing these defendants too highly. Now, the state in their answer brief raises a number of arguments, and a few of those are that this court has affirmed other appeals from Judge Tharp's sentences in child pornography cases. I pointed out in my reply brief that the Schmidt and Wells cases are unpublished, and for that reason they don't qualify as precedent to begin with. And additionally, I don't know whether those cases raised the argument that I'm raising now in this appeal. So for those, at least one, possibly two reasons, this court shouldn't consider those decisions. The Wingo case, which the state also cites, involved a different issue, and that had to do with whether the judge could consider some other impermissible factor, which had to do with the defendant's luggage. And the defendant had said, I packed my bags, but the judge said, oh, well, that means he's going abroad and he's going to, attack these children and do really bad things. And that was the argument there, not that the judge was no longer qualified, or not qualified, but able to impose sentences in these cases. Now, also in my reply brief, I cited a number of cases that have to do with the appearance of justice. The state cases obviously were cited in the initial brief, which were Nawaz against State, Scott against Henderson, and Atkinson Dredging Company against Henning. But this law has been actually quite well developed in the federal courts. And the rule in the federal courts is when you reassign on remand, it doesn't have really anything necessarily to do with the judge's qualifications, abilities, or actual bias. Rather, it's to preserve in the public this idea that our judiciary is completely unbiased. And
I appreciate that, Mr. Murphy. We only could proceed, as you know, based on the record before us, understanding what this judge has done in the past. And perhaps we got to give circuit judges credit, where I think some of us were former circuit judges. If we do something, we get a reversal from the appellate court, and we're hoping to learn from that reversal so we could improve on the next case. So in this case, looking at the facts before this particular judge, if you look what he has said, it wasn't one of those situations where you presented everything and then he's like, I'm sentencing you to X. He actually explained, and I've highlighted something that I want to quote that for you. This is in page, it's in the transcript, I can't, where, but here's what he said, quote, "This particular case is probably one of the most sophisticated in terms of categorization of videos and images, not only by the type such as bestiality, bondage, but also the specific child that was individualized in your category. To say that it's extremely disturbing is probably to put it very mildly. The sentencing," then he explained, "the sentencing guidelines calls for the bottom of the guidelines being 4,042 and a half months, which equates to over 36 years in prison." And then he explains the sentence that he is imposing. So he is basing his decision based on facts of that case, unlike Goldstein, where he went on to say, I'm concerned about you because I know people like you, even though you've only looked, you're going to be touching, and I have to worry about the public. So it's a far cry from Goldstein, a far cry from Barnhill. Why can't we look at this case based on the facts before us?
Well, I'm glad you pointed out the organizational structure element of this. My view is that organizational structure has nothing to do with the moral depravity of the crime. In my reply brief, I pointed out that the fact that somebody has organized something doesn't have anything to do with the commission of the crime, and it doesn't have anything to do with the concealment of the crime. The crime has already been committed. It would be analogous to aggravating somebody who possessed marijuana, aggravating their sentence just because they put in little cubby holes the different kinds of marijuana. But the crime has already been committed.
You're down to 5 minutes if you want to keep going or save it for rebuttal.
Do you want me to respond to the question, or?
Sure, you can finish. I'm not trying to cut you off. I'm just
Okay,
trying to
let me
provide
finish
you-
this question, then I'll sit down. So I don't think it has anything to do with the commission or concealment of the crime, and so I don't think that's an appropriate basis to impose the sentence on. Now, what Judge Tharp did was quite appropriate for a trial judge to do in the sense that he explained the sentence. Now, you don't have to explain the sentence. You said that in Goldstein. You can just impose it. And Judge Tharp could have done that. And then, obviously, it would be a difficult appeal. But instead, he didn't do that. He explained these things. And the question is, what did he mean by that? And my position is, whether you accept it or not, that's not really what was happening here. What was really happening here was he wanted to impose a draconian sentence, more draconian than the sentences he'd imposed before for defendants who were more culpable, not more guilty, but more morally depraved, and then stated on the record some bases that really did not go into the calculation of that sentence. Thank you.
You got 3.5 minutes left for rebuttal.
Good morning. May it please the court. My name is Chelsea Alper, and I represent the state of Florida in this case. This court has touched on several of the points that I would like to make today. But essentially, Barnhill and Goldstein are the exception and not the rule. Appellant's asking you to reverse his case based on pure speculation that the trial court could not learn from this court's opinions in Barnhill and Goldstein. And Judge
Well,
Kazan,
did the judge have the benefit of these opinions at the time of sentencing in this case?
at the time of sentencing in this case, yes, he did have the benefit of these opinions, but that would be the state's position that he was able then to correct his mistake. As Judge Kazan pointed out, many trial judges have been reversed, and they use those reversal orders.
Did the judge make any reference to those cases at the time of sentencing?
He did not know.
So we don't know if he learned or didn't learn from the record itself.
I'm sorry?
If the judge had said, I've read these cases, I've taken the wrong approach, I'm going to rectify it starting with this case. He didn't say that.
No, but I don't know that this was the first case that he sentenced since Barnhill and Goldstein came out. So I'm not sure that he would say that in every case if he was taking these into
And there was
consideration.
no motion to recuse based upon policy?
Not before the sentencing. There was actually a 3800B2 motion to correct sentencing after alleging judicial bias, but it was not done beforehand, which... And as Judge Slaria pointed out as well, if this court had wanted to disqualify Judge Tharp from sentencing in future cases, it's the state's position that this court would have said so in Barnhill or Goldstein when they had the facts that would support such a disqualification if this court felt the need to.
Have you ever seen a case where we've done that?
I could not find one, and I looked. I searched and I searched. However, again, as Judge Kazan pointed out, you guys really got all my points for me today. This case is based on the record. This court is bound to the record in front of them in front of you when deciding whether or not this judge was biased or impartial in making the sentence. And Judge Tharp did a very good job of thoroughly analyzing the facts of this case. He pointed out very specific instances, such as the progression from adult pornography to illegal child pornography, the categorization, which, as counsel pointed out, the categorization, the sophistication, that's a mitigation factor for a downward departure. And Judge Tharp downward departed in this case, so from my understanding, the trial court was not using the word sophistication in the mitigation statutory way. He was actually it was the adjective to describe classification. It was a sophisticated way of classifying. He classified these files based on the child's name, based on the type of pornography in it, the bestiality, the bondage. It went to the nature of his conduct and the nature of the crime. It wasn't so much a mitigation statutory factor in the way that sophistication is used generally in downward departures. And another point,
Your opposing counsel has used the word draconian in describing these sentences. Do you agree that this was a draconian sentence?
I do not. I believe that based on the facts of this case, the serious nature of the crimes, counsel has pointed out several times that, he merely possessed child pornography, that he just possessed these pictures on his computer for 3 months. However, the issue of child pornography is far bigger than that, and it's not a victimless crime, and as Judge Kuzan pointed out in Goldstein, the court is allowed to point out that child pornography is a very serious crime. It's not a victimless crime. And I think Judge Tharp actually pointed that out in giving his sentence. One of the issues in Barnhill and Goldstein was that he essentially had this fear of future touching, and that was what he based his sentences on. So protection of the community, but in a impermissible factor sense. Whereas here, he was sentencing based on punishment for the seriousness of a crime, which this is a very serious crime. It's not just having pictures. There are children who have been violated to make these pictures, and it's a supply and demand. So it's not just having pictures. But Judge Tharp pointed out that there are children that have been victimized, and he's protecting those children that have already been victimized by giving these sentences. And one of the things that the court should consider in sentencing is punishment as well as deterrence and protection of the community. And Judge Tharp did a good job, I believe, of considering those factors as well as the specific facts of this case, which he referenced multiple different types of facts in giving the sentence. And the state does recognize that this court denied its request for judicial notice for Knight v. State. However, in answering the question for the draconian sentences, the state believes it's important for this court to consider not just Barnhill's resentencing and not just Goldstein's resentencing, but also the sentence given by Judge Tharp in Knight in which he gave probation. And so if it's counsel's stance that Judge Tharp doesn't give probation ever because of this policy, well, if he gave it in this case in Knight, considering the facts of that case, then that policy essentially doesn't exist anymore, and he did learn from Barnhill and Goldstein. And also, something I would like to point out, I'm not sure that counsel would know this simply from the docket online, but Goldstein, when he was resentenced, Judge Sabella did not sentence him. He did sentence him, but it was a negotiated plea offer by the state, so he just accepted the plea offer. He did not actually come up with the sentence himself. So I thought that was fairly important to point out that, yes, it was a resentencing, but the state actually went back and looked at everything and offered a 15-year sentence. And while it's not on the record and it's not something that this court necessarily should consider, but as counsel brought it up, I'd like to point it out too. He says he's never seen sentences that have been given in these guideline ranges of the hundreds of years. However, I have. So I think it's important to note that we do have different perspectives, but I have seen several cases that this court or that the trial court has given these guideline sentences of hundreds and hundreds of years. So that was just something I wanted to touch on there. And then as well with the per curiam affirmed cases brought up in my brief, or in the brief, the state's not asking this court to consider those cases for precedental value. The court's simply just asking this court to consider those cases to show that these issues have in fact been raised in previous cases. The issue of Judge Tharp and whether he could sentence fairly based on Barnhill and Goldstein was brought up in both Schmidt and Wells. And as counsel pointed out in his brief, this court can't take judicial notice of its own files, and these files already came through. But essentially, the state's really just asking this court to look at it from this issue has been raised, and the court has ruled that Judge Tharp can be impartial, and that his sentences can be upheld. So this essentially blanket policy of reversal is something that is not necessary. Essentially, to reverse in this case, as Judge Valenti, you pointed out, would require this court to assume that Judge Tharp did not learn from this court's order in, or this court's opinion in Barnhill and this court's opinion in Goldstein. And as Judge Kuzam highlighted in Goldstein, trial judges can learn from their mistakes. They can learn from their experiences on the bench. And I know that you were essentially referencing more the past, having these defendants in front of him before, but it was a good point that this is an experience for Judge Tharp, and he was able to learn from this mistake. There's no indication in this record. The four corners of the record, there is absolutely no indication that Judge Tharp considered any type of general policy when sentencing this defendant, just because he did grant a downward departure. That's very clear. It went from 336 years to 36 years. And just because he didn't depart to the extent that Mr. Valesano wanted doesn't mean that he didn't give a thorough analysis and pick a sentence that he believed was representative of the crime and the facts of this case. And he did a great job of analyzing all the facts of the case to come to this conclusion. And I just wanted to touch really quickly, if you had any more issues on, or questions on issue 1, I'd like to address those, and if not, I wanted to touch something on issue 2. In issue 2, as stated in the briefs and as acknowledged by counsel in the brief, the extent of a departure by statute is not reviewable by this court. And the reason that this court reviewed the extent of a departure in Goldstein was because impermissible factors were considered. In this case, no impermissible factors were considered on the record, so the extent of the departure should not, the court doesn't have the authority to review that. But if this court did want to review it for reasonableness, we stand on the argument that the facts of this case, they're not pretty. I mean, he classified these children in folders. There's a folder where he classified a child by her name with 2 subfolders, pictures and videos. And in those subfolders, there were pictures and videos of that specific child tied up by her hands and by her feet, with that specific child performing oral sex on a dog. I mean, we had bestiality and bondage in these files, and he took the time to separate these files and categorize them. And that does go to the nature of his conduct. No, it's not a statutory sophistication in the sense that the mitigation would be a statutory sophistication, but that's not an issue because Judge Tharp did downward depart. It just goes towards the nature of his crime and pretty much the effort he put into this crime as well. And admittedly, he admitted in the sentencing hearing that this wasn't the first time it happened. He said, I want to be candid with the state. This is just the first time I was caught, and it's happened for 5 or 6 years. I did it once, and then I kept them for a couple months and I deleted them. And then I did it again, kept them for a couple months and deleted them. So this was an ongoing issue that it was mentioned that he sought help for, but no help was given, no help was received. And that's another thing that the court could have considered, that all these people that said, we can help, he could have reached out to before, or he did reach out to before in one case, and no help was given. So when we look at the reasonableness of the sentence, when you're looking at the legislative intent of punishment, the protection of the victims that have already been victimized, which is clear that there are certain victims that he has a privy to because he has individual folders with their names and it's been categorized, as well as the types of pictures that there are. The appellant admitted himself that he began with adult pornography and then he progressed to child pornography because it seemed reasonable. And that progression is something that could be taken into consideration as well when the sentence was fashioned. And something that the appellant points out in his brief is that there were only 3,000 images of child pornography, but there were 742,000 images on the computer. The majority of those images were child erotica, and while that is not illegal, child erotica, as pointed out by Detective Groh in the sentencing hearing, that's children who there are nude pictures of them, but not in sexual poses, or children in sexual poses, but in lingerie without their genitalia showing. So while those are not illegal, they still go towards the nature of this crime, and it's something that, while the court can't sentence because it is not a crime and it's not, it's not even an uncharged offense, it's not a crime, it's still something that when you're considering totality of the circumstances, it's not a mitigation as appellant tries to paint it. It's an aggravation because there's far more than just 3,000 pictures of child pornography thrown into 742,000 legal pornography photos. So in this case, the sentence, it was reasonable. It was absolutely reasonable to give, he had 2 different case numbers, 300 counts total, 3,000 images. In both case numbers, he was given the statutory maximum. He wasn't even given over the statutory maximum. It was a downward departure from 336 years. And the trial court has the discretion to run those consecutively. And that's what he did. He ran the 2 cases consecutively, gave statutory maximum, and he based it on the facts of the case. The 4 corners of the record show that he absolutely considered only the facts of this case here, and it's the state's position that he learned from his experience, or he learned from his mistakes in Barnhill and Goldstein. He did this court's warnings, he did this court's directives, and sentenced appropriately. So we're asking this court to affirm sentences and convictions, and if there are no more questions, the state will rely on its brief.
I'd like to make a few points just in the order of they were presented. At the time of the sentencing, Judge Tharp had the benefit of Barnhill but not Goldstein. Goldstein was decided in January of this year. The state speculates that that you would have held that Judge Tharp could not consider these cases anymore. You would have decided that in Barnhill and Goldstein, but like I discussed before, that's not necessarily so. You just decide the cases based on what's presented to you, and courts are on their firmest footing when you decide as little as possible in each case. In discussing the draconian sentences, as I've discussed before, the state says this is a question of supply and demand. There's no record basis for that. There was no commerce here. He simply signed up for a software program that downloaded this stuff. So the photos were already produced. He didn't purchase them. This would have nothing to do with the supply and demand of child pornography.
You know, the reason why I asked about the draconian sentences, because it seems to me, if everybody agreed these are draconian sentences, that would contribute to us saying, well, per se, policy was followed here. It makes it a lot easier to connect the dots. But if these are just lawful sentences that are heavy-handed, it becomes a lot more difficult to relate the policy to the sentence when nothing was announced one way or the other. That's the presumption we have to somehow deal with.
Are you connecting draconian with unlawful, or? Because I'm just using draconian.
Well, your definition of draconian might be different from their definition. I don't think there's a universal definition, except the one that says if they're all heavy-handed every single time, that's not necessarily draconian. It's just a high end of a permissible sentence. So that's the difference I'm having.
Okay. I'm saying that these are pretty heavy-handed and unusually heavy-handed sentences for child pornography, in my experience.
No, I understand that.
On the issue of supply and demand, though, if I understand the record right, it's not just that the facts aren't just that information was being downloaded onto your client's computer, but also that people using that service had access to existing files on his computer.
I believe that's the way it works, but I don't think it contributed to the supply and demand because he was not a producer of child pornography. These photos already existed and were already available from other sources. So this didn't affect the supply and demand calculation in the child pornography.
More of it was available to more people because there was an additional channel of distribution, right? I mean,
but the supply would be the same. I mean, you could, if you just signed up for it, you could just as easily get it as he did. There's an infinite supply of what already exists. So the fact that it's available from another source doesn't affect the supply of child pornography, if you understand.
I get your argument.
Okay. You don't have to agree with it, but you got to understand.
I'm going to give you an extra minute since we've used all your time.
Okay, I appreciate that. There's been a lot of talk about the bestiality, the bondage, and the categorization. Just look at the facts in Barnhill and Goldstein. In Barnhill, that defendant had collected child pornography continuously for 10 years. He had amassed 415,000 images of child pornography, and he'd placed them in an elaborate organizational structure. All of those facts are significantly worse than what Mr. Valesano did here. In Goldstein, in your opinion, Judge Kazam, you described his child pornography collection as involving almost any imaginable sex act, which I understood to mean it would include things like sadism, bestiality, and the other one, bondage. So I don't think that there's a good way to distinguish between these cases. If anything, those ones are worse. And in Goldstein, the state mentions that that was a plea agreement. But remember that the trial judge had to accept that plea agreement. Otherwise, it wouldn't go forward and you'd have to do an open plea. And the trial judge
You've got about
did.
half a minute to wrap up, just so you know. I'm have to cut you off at some point.
Gotcha. And then I just want to, I think the state misspoke. It was 712,000 images of child erotica and adult pornography. The record doesn't say how much of it was adult pornography and how much of it was child erotica.
And
But the number was...
But I want to assure you, because, you know, the erotica, that's not a crime, so that's not being considered. I just want you to know that we're only considering based on the facts.
That sounds good.
And the crimes that he's being charged with.
Okay, I agree with that approach.
All right.
So we're asking you to vacate the sentence and reassign on remand to another judge. Thank you.
Thank you both.